All right, so we do have translation services on the closed captioning can translate from English to about 100 languages, and then back from that language back to English. So I know that we have one person who's a primarily a Spanish speaker. So we met earlier with that person just to make sure we're on the right page with getting that going and make sure it works for that person. So hopefully it's working now. I'm just gonna. So Alejandro, are you getting the translations? Yes? Okay. You're muted right now. All right. We have 28 people joining us. That's less than we have connecting, or less than we have intervening, but I think, well, maybe not. We do have a couple of duplicate people on the list. '21. Oh, that might be Dempsey. I think we're missing.
I am representing two people on the list also.
Okay. So you're standing in for three?
Yes.
Okay. Well, let me just ask anyone else appearing on behalf of someone else who's intervened?
Actually,
I'm also representing Cody Boyd.
Yes. Okay. Right.
I was going to say I have Steve and Maria Borzik,
Okay.
Brooklyn Kinner, Kimberly O'Brien Silk, PJ O'Brien, and Nancy Emmerich.
Okay. Emmerich, I didn't put her on the
I think she was added after this
Oh, that
document
was the one. Yes,
had
right. You're
gone
right.
out.
Okay. Yeah, you're right. Okay, good. Well, looks like we do have just about everyone connecting then who we're expecting. So a couple people joined us by phone. All right, before we get started, let's try to identify the people who I can't identify yet by their screen name. So we have one person who called in. Their number ends in 964. So you just need to push *6 to unmute your phone and just let us know who you are. So I'm not going to keep people on that I haven't identified themselves. This pre-hearing is for parties and people who've requested intervention. So it may be the case where we'll get someone coming in now joining us. There's still an opportunity to join in, and we haven't really set any schedules yet. So theoretically, we could take you on as a party now. You'd be late, but no harm done. But you need to let us know who you are. I'm sorry. I'm hearing somebody, but I don't know who's speaking. Is it Aileen?
Yeah, Aileen, Aileen Kenny. I did dial in. I'm having some issues with Zoom, but that's not the end of my phone number. But I can, but I'm 7031. If I'm the right number, that's who I am.
Now I see you on Zoom. I have your Zoom
Okay.
connection. Yeah, it looks like you're a phone call, but
Okay.
your name actually shows up for some reason. So,
Okay.
so
Right.
it's Tillett. Is that Tillett's your last name, right?
No, Your Honor. Eileen,
Aileen.
it's Aileen Kenny.
It's Kenny.
affiliated
K-E.
with Whitewater Solar.
Okay.
Yep. Kenney.
Okay.
So my name is Ann Tillett.
Yes. Okay.
I thought I joined with my name, but maybe it joined up
Yes.
as my phone number. I'm not sure.
No, you're good. I just heard it wrong.
Okay. Okay,
You're
thank
good.
you.
No, I got you there. You're good. How about House? Haus. Can you give us a little more clear indication of who you are? Looks like you dropped out.
Yeah,
No,
my
there
name
you
is. Yep, I'm here. My name is Nick Haas, and I'm with Desiree, part of the project.
Okay.
Sorry, he's a Whitewater Solar Master.
Yeah. Oh, sorry. Yep.
Okay, well, so this is one thing we'll have to review. We can't really have people speaking over each other. So just for House, can you just review again who are you with?
I'm with the project with Whitewater Solar.
Okay, and what was your name again?
NICK HAUS.
Ah, great. There we go. Appreciate that. Yeah, so for the Whitewater Solar people, if you could prefix your screen names with that WS next time. There's just so many people to try to do that for everyone. It's going to be quite a challenge. So if you guys could just pre-fill that next time you guys join in, that would be really helpful. Yeah, so we do have 2 people joined us by phone. And I just have their phone numbers. So guys need to unmute and let me know who you are. First number ends in 964. And you need to press *6 to unmute your phone.
Judge, I think that might be Bill Salsky. If he doesn't make it on, I was going to proxy for him.
I see.
I think that might be his number, sir.
All right. Well, we'll leave
That
in.
is correct.
Ah, great. There, I hear you now. Thank you. Okay.
That is correct. I am on.
Great. Thanks. Bill, I'm just going to put Bill S. I got a lot still to do here. And well, yeah, one more number there was phone number ending in 059. Who do we think that is? And remember, unmute by pressing *6. Yeah, looks like you're unmuted. Can you hear me?
Yep. Hello.
Yes.
This is
Hi.
Drew Vielbig. This is Drew Vielbig with Whitewater Solar.
Ah, okay. Let's put Whitewater Solar in there. All right. Looks like we've got everyone identified.
Your Honor, I just want to identify myself. I'm probably the last one given my name. My name is Martin von Rosenberg. I am also with Whitewater Solar.
Yes, and your name, yes, all right, I'll just put your, yeah, I was wondering who that was. Not recognized.
Didn't want you to miss me.
Did not recognize that as a party, so yeah, there you go, quite great.
I am on too. Can you see me? I'm Bob Platt, 3930.
Let me check.
You let me in and I can see and hear you.
Yeah, you're in. If I can hear you, you're in the Zoom.
Right.
You may need to turn on your screen or something, but I don't.
Okay.
It's our Platt's phone. It's a black screen with our Platt.
Ah, okay. Yeah, so if you're,
I'd be happy to put you on, but it doesn't give me that option.
well, I can try. Let's see. I'm going to ask you to start video. Maybe that'll give you like a button to push once I do that.
There it is. There it is. I think.
Oh, yeah, you just went on and off a little bit. So, I got you. Okay, perfect. Great.
Thank you.
So you are now. What was your first name again? I'm sorry.
Robert Platt, Platt.
Great. Okay. Well, it looks like the people joining us, looks like it's slowed down a bit, and we definitely have a lot of people connected. So I'm thinking we have everyone.
Is there a passcode to the meeting, sir? I'd like to get on my computer, but it's not taking a passcode.
There is no passcode per se. On the notice of hearing, you were given that link here, and it's on the screen share. That'll get you right into the meeting.
Okay.
And the QR code will do the same thing. So
Yeah.
yeah, there's
Okay.
actually, if you have that link, you don't need a code. The meeting ID is down here, though. If you're calling in, you can use that code. You may need to, yeah, I think you'll need to enter that. Dial the number.
Yeah, I
You don't want to
appreciate it.
dial in. You want to just connect on your computer. Well, for
Right.
now, I'm just going to let you be where you are. I mean, I can see you and hear you okay. You're just
Okay,
having
great.
trouble. You're having trouble seeing us is the problem, right?
No, I can see you. Okay.
Okay.
I'm all good. I'm just on my phone. I'd rather be on my computer.
Yeah,
And if there's
yeah,
no
it would be
reason,
better. It would be better. Yeah.
it's looking for a passcode for me, but I'll keep trying.
Yeah, it would be this number, this 809-513-2930.
Yeah, I dialed that as a phone number and got a foreign language.
Yeah, that's not the phone number. That phone
Yeah.
number. Yeah.
Yeah, and it didn't work for me either. I got that one, so not sure what the problem is here, but
okay.
I use them all the time, so thanks.
Okay, well, hopefully this is one of the reasons why we're doing a pre-hearing. We get everyone on, get them connected, get to hear if their audio's working, their camera's working, make sure everything is up to speed. So that'll be just one trick that you'll need to do for next time. But all right, I think we're good to go here. So we're gonna get started, and let me just explain a little bit before we get on the record. So this whole process is set up to create the record in the case, and the record is what the commissioners use to make their decision on the application. The commissioners are 3 people in our agency that they run the agency. They're appointed by the governor and usually approved by the Senate, and or they're awaiting approval. And they review the record. They make a decision on the application. They can only use the evidence that we provide them to base their decision. So the commission generally has the power to approve an application, modify it, and approve it with those modifications, or deny the application. So so my job is to put the record together and give it to the commissioners. So part of that record is the transcription of the hearings. That's why I'm previewing with this is that we have our court reporter here, Debbie Harnan. She's got the headset on. Just give them a wave there, Debbie. She's been with us for years. She's great. She will be listening to everything you say and typing it down. So the important thing is that she can only listen to one person at a time. So, and the other thing is to please speak slowly and clearly, much better than I'm doing now, so that she can keep going and follow along. So it's what she types down is what the commissioners are going to read. So that's an important part of this whole process. So let's get started now. We get to get on the record, and Debbie's going to start. So welcome, everyone. This is Docket 9828C100, the application of Whitewater Solar for CPCN for the Whitewater Solar generation project. My name is Michael Newmark, the Administrative Law Judge for the PSC. We're connected through Zoom with parties, potential interveners, and commission staff in attendance. We are going to discuss, like we usually do at a pre-hearing conference, we're going to discuss the parties, schedule issues, and facilitating matters. And let's just go off the record for a sec. Can everybody hear me okay?
Yes.
Okay. It's got a little bit of a interruption there. Okay. So let's get back on. So once we come up with, once we discuss those items, I'm going to make decisions on them, and then those will be the rule of the case. Basically, you'll be bound to following those decisions, and we'll go from there. And we'll like I said before, we'll do the process of creating the record. I did want to introduce myself a little bit before we get started. I've been at the PSC since 1999. I was an attorney with the commission for 10 years and then switched over to the ALJ position in 2009. So not going to say I've seen it all before, because it's one of the best things about this job. There's always something new. But I've been at hearings where we've had a number of parties intervening, people with different levels of expertise and familiarity with our process and legal process as a whole. I try to not let the procedures derail someone's opportunity to present their opinions and their position on a case. But I think everyone needs to realize that contested case is something that is set up in the statutes, and it definitely involves, for the parties, it involves their substantial interests and their rights. So on all sides, I need to be fair and impartial, and I need to make sure that we're adhering to the procedures in order to provide everyone with due process. So we definitely need to make that balance. So when we go through the process here, you'll see that there are some very picky, detailed, specific things that I'm expecting parties to do. Some of them are deal breakers. Some of them aren't. So there are certain things that you can and can't do, and other things I can be flexible on, particularly when it comes to the filing requirements and setting up your documents properly. That's something that we do for organizing a case. When we have cases, we have many cases running simultaneously, and we have many people involved in this particular case. So adhering to those procedures are going to be greatly beneficial to helping move this along and making it digestible for the commissioners. They're our audience here, and I think what we want to do is make it easy for them to understand you. So when things are standardized and they expect to see certain things, and when they get them, that's helpful. If they see things they're not expecting, it gets very complicated to sort of keep things organized. So I will attempt the best we can, stick to those procedures and requirements. I realize someone who's just starting and is not involved in an organization or has an attorney background or attorney helping them will have some difficulty with this. I can be flexible with that. But on the other hand, when it comes to adhering to evidentiary standards, making sure everyone has due process, making sure people are following the legal requirements, I'm going to need to stick to those as well. So there may be times where you're not going to like what I'm going to say. So I just wanted to make sure everyone's entering this with open eyes. So next thing we need to do is have appearances be stated on the record. So I know everyone is here, or at least they have a representative here. I do have the service list. So what I'm going to do is just as quickly as we can, go down the service list in alphabetical order and just see if we have someone at the pre-hearing who's either one of these people or is representing this person. So let's begin. So we're going to start with Bochart. And
Patricia Barker, I'm here.
You're here. That's Patricia. Okay.
Patricia, correct.
I think I'm going to let's go off the record. So I'm going to change my view so that the person speaking is going to come up. So we're off the record one more time, Patricia. Just let me see if I can find you on the list of people here. Go ahead and just say your name one more time.
Patricia Borkert.
Okay. So is there any way you could get your screen on, or are you not?
I do not know why I'm having trouble with my video today.
Okay. So we're still off the record. That's fine. But what I wanted to say was, yeah, to the extent we can possibly, let me just invite you to turn on your screen. That may help. Did you see anything pop up there?
I did get a pop-up that said start your video.
But it's not working. Okay, that's fine. So one reason why we have people do video as well, just for validation purposes, first of all, but also it's an accommodation for people who have a hearing disability. If you're reading lips, we provide the video connection as part of that, accommodation. So if you can try to fix that for the next time, that would be greatly appreciated. So
I will do that. I apologize.
no, that's all right. Don't worry. So let's get on the record one more time. So Patricia, are you also representing Bruce?
Yes, I'm representing Bruce, my husband as well.
Okay, great. And Borzik, is Borzik in attendance? One of you?
Borzik is not in attendance. Michelle O'Brien will be representing both Steve and Maria.
Okay, great. And yeah, just the two of them. Okay, how about Boyd? I think we have a Boyd here.
Madeline Boyd is here and also representing Cody Boyd.
Okay, perfect. Thanks. Clean Wisconsin.
Good afternoon, Your Honor. Katie Nicola representing Clean Wisconsin.
Okay. So we have two Dempseys, and I can review why I did that before I have Dempsey S76 because of the location, and then we have another Dempsey listed as a separate party because of the location is different, West W198. Do we have any Dempseys with us? Anyone representing them? Okay. All right. So let's move on. I know we had Nancy Ermrich. Someone was representing Nancy. Is that right?
Yes.
Your
Michelle.
Honor,
Oh, yeah. Go ahead.
I see Sean Dempsey is here. I'm not sure if he just can't get his audio to work, but Sean is
Oh,
here.
yeah, I see him there.
I'm here.
Okay, let's back up then. Sean, you're here. Okay. So is your camera going?
I'm having trouble with it.
I see. It looks like it's just facing the ground. Okay. So you're representing, so I have the Dempsey S76 address.
Yep, and the 198.
And West 198, you're representing them both?
Yes.
Okay. All right, we'll move on then. Nancy Emmerich, who is representing her?
Michelle O'Brien.
Yeah, okay. And Lori Hoyt, you're here. Just check in with us, please. You're muted.
Good afternoon, everybody.
There you are. Okay, great, thanks. And someone was representing Brooklyn, is it Nur?
Pinner, pronounced the K. Yep.
Okay.
Michelle O'Brien as well.
Okay. Jared Caldwelter, you're here, I think. Just check in with us now. There you go.
Yep, I'm here.
All right, I like that background there. Yvette, I'm gonna not be able to pronounce that. Go ahead and pronounce your last name for me.
Hello, Judge. My name is Yvette Losell, and I'm here.
All right, great. And are you representing anybody else, or at this point?
No, just myself. Thank you.
Okay. All right, so we have Kimberly O'Brien, Silky.
Michelle O'Brien.
Right. And I'm sorry, I'm talking over you. Are you representing everyone then for now?
Yes. And I don't know if it matters clarification. For Patrick and Michelle, we are only O'Brien. I see it listed as O'Brien Silk.
Because you're at the same address, I was just going to use that as the party name. Is that okay, or do you want to separate for different?
The party name could just be O'Brien.
Okay. All right. That's fine.
Thank you.
All right, I'll note that. Now we have Alejandro Perez Gomez. So just check in with us now. So I'm gonna unmute you.
¿Me puede escuchar?
Yes.
Buenas
Hello.
tardes.
Okay, we got your appearance. Thank you. And Margaret Platt. Oh, we have a number of Platts. So who's representing Platts?
Robert Platt is here.
Yes.
And if she's not on, I'm representing Margaret Platt.
Okay, great. Thanks. Who's representing the Public Service Commission? PSC, I know you're
Sarah
there.
Coons, representing the Public Service Commission.
Okay, great, thanks. Okay, we're gonna skip down when we get to Whitewater Solar. We'll ask for them. Renew Wisconsin.
Good afternoon, Your Honor. This is Andrew Kell with Renew Wisconsin.
Right. Slasky, I think you're on the phone. Just let us know.
That is correct.
Okay,
that is correct.
Thanks. Wendy Schneider. Are you here? Yeah, I see you there. I'm going to unmute you. Go ahead, Wendy.
Here. I'm here.
Okay,
Hello.
thanks. Mark Scholl. Are you here, Mark?
Your Honor, I could proxy for Mark if he couldn't make it. If that's okay, I would proxy for him.
Well, that is an interesting situation here. So he didn't let you know about not being able to attend.
No, I haven't heard, but I don't know, but I just wanted to offer if that was a possibility.
Yeah, I don't know if I can do that at this point. Let's put a pin in that and move on. Okay. Jeannie, I'm not gonna be able to pronounce that name. So go ahead, Jeannie, are you there?
Actually, Your Honor, she just emailed me. She's in Arizona and she said she can't make it and asked me if I could proxy for her. She just emailed me.
All right, that's good enough, I guess. Okay. Diana Schroeder or Schroeder? Diana, are you there? I'll spell your name because I'm messing it up. Schroeldl? No?
Yes, that's correct. Schradel.
Oh, there you are. Okay, I thought I'd seen you there. Stakowski, I know you're here. Just let us check in with us.
Hello, Judge. Yes, I am Pam Stakowski, and I am also representing my husband, John.
Perfect. All right. Ann Tillett, I know you're here. Just give us indication now.
Yes, good afternoon, Your Honor. This is Ann Tillett. I'm here.
Great. And are you also connected with Wade? Are you representing Wade?
No,
here.
I'm not. He's here.
Oh, you're here. Okay.
Sorry. Yes, this is Wade Tillett. I'm also here.
Okay, great. Okay, we have Richard Wagner next.
Yes, I'm here, Richard Wagner.
Great. And Whitewater Solar.
Brian Cahill appears on behalf of Whitewater Solar, and also present are Aileen Kenny, Drew Vielbig, Nick Haas, and Martin Van Rosenberg.
All right, great.
Sorry, Martin.
Oh,
Van Rosenberg.
Thank you.
All right. And Wood, who's representing the Woods?
I am Alan Wood.
All right. Okay, great. So we have everyone checked in. I guess still maybe a open issue, maybe Mark Scholl. But yeah, I don't know exactly what we'll do with that at this point. So that's all of our parties. So I did want to review. Now I know you guys have been told a couple times about combining forces and possibly getting representation. I don't want to create barriers for the public well, not the public, for people with a substantial interest to join us as parties. But as you can see, just in terms of checking us in, it took a half an hour. So I mean, I would emphasize that there is some benefit to combining together into a group. And why I would say that is for administrative efficiency. So I would think, and I know you've already probably thought about this, so you probably have a quick answer for me, and I'm pretty sure what it is. But I wanted to just be able to communicate this on the record and get you thinking. What I want you to consider is that if you all are have interests in, if your interests are all in alignment. So what I mean by that is you have the same opinion about the project. You are basing your intervention on your location to the project, where you reside is, or maybe some property you own is in close proximity to the project. You're all able to get along, and it all seems like you can join a group productively. I would encourage you to do that. I think there is a power in being able to present your position with a common or singular voice, and it doesn't mean that you wouldn't be able to make your presentation individually. It just means you'd be organized as one group. So there's what I would propose, or how I would envision this, is how we do this in a number of cases. And I did want to just show on the screen an example of that. We just got this intervention request in another case, and it's this group that's formed called Chippewa Valley Preservation Alliance in a different docket, totally unrelated to this. But what they did is, it's just a bunch of, it's a list of landowners, people whose homes are in the project area, who've banded together, and they want to express their opinion on this case as a party. They've actually hired an attorney, and I wasn't going to show that on the screen who that was, but they they hired an attorney, and they got together as a group. Now, the reason why I'm bringing this up is that there's so many people here. It may be beneficial for you to join forces in that way, and it may not be it may be very cost effective for you because there's so many people involved. But what I would say is that this is a person, if you had an attorney, you created a group, that person would be able to act in your best interest and give you sort of the roadmap as how to participate and how to meet the legal requirements, and be able to explain those requirements to you. I could do my best to give you sort of a general view of what we expect, and commission staff attorneys can assist to some degree, but we can't give you legal advice. We can't tell you to, say it this way better than the other way, or, you want to save that statement for rebuttal, or there's many ins and outs in this process that an attorney could really help you out with. And I'm no big proponent of hiring an attorney, trust me, but I see this as a kind of a train coming, and we're kind of sitting on the tracks, and there is a train coming. So the attorney may be able to derail that train a little bit for you. So this group actually formed they're a non-profit association. So that would be what I would envision. It's just a group of people getting together. There's no formality involved in terms of creating an organization or incorporating or anything like that. It's not that kind of organization. It's just a group of people speaking in one voice. And to the extent, since you have so many people involved, it may be doable to hire someone to help you out if you all pitched in. So just wanted to put that out there. I think that may be in your best interest, but it's not something you have to do. I won't hold it against you if you don't, but I think you would find it a much more effective way to participate. So but what I wanted to review then is, so I don't know if anyone has any opinion about grouping together. I think in this situation, I don't usually have people raise hands, because it just adds another layer. But if you could raise your hand, if you wanted to comment on whether you'd be willing to join a group, just give you a second to do that. So no one wants to comment on that? Okay. Even to say you don't want to, let me hear from you.
I would like to just comment in that I think our the people involved, at least at our level, probably like to discuss that before we commit to anything.
Yes, I understand that. And that's why I was trying to give you that idea in the letter, to maybe kind of facilitate that ahead of time. I totally get it. But I would say seriously consider it. So I'm just talking to all of you. If you think you meet that requirement, so you can get along, your interests are all aligned, your position, your opinion on the project's all the same, I think you'd benefit from this. And the other thing I would add is, you may not need to all, because when we have people all intervening and want to present their story, they'll all kind of cover the same thing. But if we have someone here who's like an engineer, they may be able to focus on that. And then someone who's a farmer may be able to focus on, the agricultural impact. So you can sort of specialize, but you can say we all agree with what everyone's saying, but I'm going to talk to my experience and or my expertise, my specialty, and I'm not going to talk about the things I don't really know about or don't have experience with. I'm going to let the other person in the group talk to that. So that way that's also a benefit to the record and just helps us kind of process the bulk of the information we're going to get. So that's another reason you might want to think about that. So I don't know if it would help facilitate this if we just said, like, if I gave you guys like 2 weeks just to tell me yes or no, would that be reasonable? Just see if you want to talk about it, see if you can come up with a plan. If you guys just don't want to do it, just tell me no. But if I give you like 2 weeks, that's probably, I'm not hearing.
Sounds great.
I'm not hearing anyone opposed.
I'm sorry, who said that?
Jared, sounds great. 2 weeks.
I don't see what, I just need your last name.
Co-author.
Thank you.
So let's see. So let's just make a date. So let's say February 6th by noon. Just want to file that on IRF. And just if you want to just pick a representative, someone who could just speak for at least for that purpose, just to say we all got together. We don't want to form a group, or hey, can you just group us together? I'm authorized to say that these people, and just list the people. These people want to join together. So you'll act as one, and then the important thing about that as well is if we could have one person sort of designated as the filing person, or the person that I could be engaging with in terms of getting the formats and the filing requirements enforced. So, there's a lot of complicated things, and I'm going to end up most likely just having you refile stuff, and I'll give you instructions on what's wrong and how to fix it. But instead of me having to go back and forth with every person individually, if you guys do form a group, you want to designate someone who will be that contact person for format. And if you could just let me know who that is, that'd be great. So it's off the record. Bob is joining us.
Yeah, I'm just going to switch to my computer now. I was
Okay.
able to somehow find my way in.
Sure. Gotcha.
Thank you.
All right.
I've been here.
All right. So
may I ask a question about your group discussion?
yeah, we're off the record. Do you want this? Yeah, let's go back on the record in case I'm going to give you information you want to read about later. Yeah, go ahead, on the record.
My question is this: if you're offering for us or asking us to help with the administrative process and asking us to group together and join efforts, obviously we would all and are all, I believe, I think everybody's committed to being as efficient as possible and making sure we do things correctly. But I think also asking an offering for us to group together, definitely we would need more time, because if you're asking us to come together and collaborate, some of the time frame, and I don't want to jump ahead to the scheduling, but I just want to get that in your head that we were already at peers tight, but if you're asking us to come together and work together, we would definitely need the time to do that.
Okay.
So I just wanted to put that into the discussion.
Got it. You can be the advocate for this group. Yes, we'll put a pin on that, but I think we're going to be talking schedule, and we can discuss, how much time we're going to need. It's just another rationale for extending giving you guys more time. So I appreciate that. Okay, so we're going to see if, so I'm just going to go over one more detail about the applicant, the intervener, the list of parties. So I know we're missing one person from the list who came in later. That's okay. I'm going to fix this, and you're going to get so this is called the Notice of Pre-Hearing Conference. You're going to see a pre-hearing conference memo will go out, which will have sort of the final version of all these propose things in it. So once we get through this process, you'll see the pre-hearing conference memo. This will all be fixed. But I think we're gonna need, I wanted to just let you guys know what I was doing with the last names here. This may not matter if you guys group up, but I was basically grouping up the people in the same location. I just do that because as a matter of course in all the cases, because I just assume that they have the same interests. If they don't, they can tell me, but I know there was a number of people who had emailed and filed requests to remain separated. But I just wanted to emphasize it doesn't mean you individually can't file something. It just means I'm organizing you under your last name by location, just to make things a little more manageable. And also just to give me a sense of who's who. So if I know, like with Dempsey, like I know you're in a certain location, I know who I'm talking to. If I'm talking to Dempsey, someone in the S76 location. Now, maybe that doesn't matter in the end, but I just always just do that as an automatic function, and then we can change it later. So I did want to review just to make sure if we had those designations, if people are okay with that, or if I need to separate things still, or separate them again. It looked like a lot of people are just husband and wife, and are one's here representing the other today. So I guess if there's anyone who wants to comment, do they want to be separated again, and why, or do they want to combine, and why? So so you just chime in. Otherwise, I'll just leave it the way it is. So if anyone want to just chime in on that, go ahead. Okay. All right. Sounds good. Okay. So I know we just have one person. Sean Dempsey is the only person representing both Dempseys here on the list. We should still keep the locations separate, or do you want to just combine into one Dempsey? Does it matter to you?
I guess it doesn't matter to me.
Okay. All right, that's good. So let's move on. First of all, the next point. So let me say there was no opposition or objection to everyone's interventions. I can now declare that everyone here is party. Everyone on the proposed interveners list, including Emmerich, which is not on the list.
Your Honor,
Yes.
could I just ask a question?
Yeah,
So, if Wade and I wanted to be listed separately, can you do that for us?
I can. I just don't know why we would. If you can just explain to me why you'd want to do that.
We won't have all of the same expertise and reasons and arguments, I guess.
Okay.
So I don't think our interests are the exact same. So I think it would be more beneficial to have us listed as two separate people.
Okay. So and we can do that. I just wanted you to know that you would be able to, even though you're combined under your one name, you'd still be able to file testimony individually. So in that sense, it really doesn't matter. Wouldn't make a difference. One thing I have to say though, in terms of party participation, so after the hearing, there's the opportunity to file a brief in the case, which is the legal argument. This is why the evidence shows that the project should or does not meet the legal standards. That's what the brief is for. So the rule is there's one brief per party. So if you're saying your arguments are different, then that makes then there's some sense of separating. You get to file your own brief. Again, if ever it may be that you may have a different take on something, but if your interests are aligned and you oppose the project, or you have reservations about the project, it may not be that you need to file a separate brief to get that point across. So you'd probably want to consider that. So same thing with grouping up. So if people group up, instead of filing 21 briefs, you'd be filing one. And right now the maximum page limit for a brief is 30 pages for the first brief and 15 pages for the reply brief, the one that you submit later. Now, and we can talk about changing that page limit because there's so many people involved, but I think we want to also consider how much the commission has to read and whether it's better or worse that they get 21 briefs that say, maybe similar things but slightly different, or one brief or a few briefs that kind of really hone in on the arguments that you have. So another thing for you guys to think about when you talk about grouping up. But for now is it Tillett wishes to separate?
I would like to,
Okay.
especially since it sounds to me like you're saying at this point we would need to know if we'd want to file a brief together. And so I would say the safest thing would be to say list us separately.
Okay. All right. That's fair. Yeah, that's something you want to consider, right? And so there we could make some exceptions, but I think we could also consider extending the page numbers, the page limits, if you guys were going to group together. I think that would be fair. So that's something we can deal with if you guys do decide to group together. But for now, I'll just note that we'll keep Tillett. So we'll put Tillett into two different parties. Anybody else?
Thank you.
Okay. I'm just trying to find a pen that works here, but I'll have to just check on that. Make sure I do that when in the future. Okay, so that's the party list. So I can say that everyone on the list is a party, whether they're combined or not. But there's been no objections to intervening and participating as a party. Issues. What I have on the screen here is our standard issues list. It's kind of a catch-all, although you might not agree with that. But we do use that in just about every CPCN case. I'm sorry, let me not talk too technical here. And in these major construction cases, this issues list pretty much reflects all the standards that the commission is required to apply in these applications. So I did see that there was some questions about adding some statutes, and we can talk about that. Just going to go off the record for a second, give the court reporter a break, and also find the list that I had for that.
Sorry, while we're off the record, did you say you're sharing your screen? Am I
Yes.
the only one that can't see it?
I don't know. Are you on your phone?
I'm on a phone, so I can't see it.
Yeah,
I'm on my phone, but I didn't call in, so usually I can.
It should be available. You may
Okay.
need to swipe something so that you're in that mode that you're viewing it. But
I'll play around. Thank you.
Yeah,
I just
don't
wanted to
know.
make sure I didn't just mishear.
Even
Thank
if you see it, it's awfully hard to read.
Yeah, I understand that. I apologize. That's the best we can do. This is just the notice of pre-hearing conference that I was showing you guys. So you guys should all have your own copy of that. I thought I had a list of the statutes. Hang on. That's unfortunate. Okay, I'm not finding it here. Let me ask you, Kara, do you have the list of the statutes? I emailed you those at some point with, oh wait, I think I got it here.
I can find them if you need them.
I got it. No, I
Got it? Okay.
I just had it in a very weird, a very weird title for the file name. Okay, it's not real, actually very weird. It just didn't think of it. Okay, so I'm gonna try to make this a little bigger. The screen share anyway. I think this might help. So I'm only sharing just a bit of that document. Hopefully it looks bigger for you guys. Oh, hang on. And it looked like, so what I have here, this on display here is the proposed issue, sorry, the proposed issue that has the normal, sort of our regular standard language. And then that some interveners were requesting additional statutes be attached to the issues list. So so let me go through that list. That's the only ones that I saw, but when we're done, we can add more if you have more to discuss. So the first one that I saw was Wisconsin statute 196.487. So basically what I'm going to go through is I have a picture of that statute here. So that statute relates to reliability of electric service. So I can, to me, these are obviously, so let me not bury the lead here. To me, these statutes don't apply to this case. And I can explain why, but I can also hear from people first if they want to make an argument as to what they were thinking. If you're just kind of curious about, what these are, then I can just go ahead and explain, why, in my opinion, so far at least, I don't think they're going to apply here. And I mean, and also I should probably also give the applicant an opportunity to chime in here and give their opinion. So so maybe that's something I should probably do first and just say that some interveners were asking to add these statutes to the issues list, and I should ask if the applicant has any comment on that first off.
Your Honor, Whitewater Solar agrees with your initial statements that the 5 statutes listed here, there is a 6th, I might add. None of them are applicable to the Commission's consideration whether to approve this under the CPCN statute. I'd be happy to go through and explain why for each. But I don't know if that's necessary at this point.
Well, why don't we just get your initial take on those so people can understand where the...
Do you want to be on the record for this?
Oh, no, we're not on the record this whole time.
You told me to go off.
Oh, when we were looking at documents? Looking for documents? Okay, that's fine. Yeah, let's get on the record. You're too small. I can't see when your hands are up.
Should I stay like this?
Yeah, maybe. Okay, so let's back up a bit. So we're reviewing the issues list. We discussed the issues that we put in CPCN cases as a matter of course, our standard issues list. Some interveners had some additional statutes to add, and we're asking to put those on the list. So I identified 5 of them, but I think there may be 6. And I asked the applicant to just give us a brief summary of its opinion of those statutes and whether they apply to the application. So go ahead, Brian.
Thank you, Your Honor. Applicant's position is these 5 statutes and the 6th, which is Wisconsin Statute 91.84, don't apply to the Commission's decision of whether to issue a CPCN for this solar facility. It's important to point out that this is a wholesale merchant plant. And looking at that first statute, 196.487, That relates to reliability of electric service and allows the commission to order certain utilities to invest and construct additional infrastructure. Very different situation than here. The next statute, 196.495.
Can I just interrupt you just for
You
a
bet.
second? Could you just explain really quickly the difference between a utility and the applicant in terms of their legal status?
Sure. Public utility is defined under 196. I believe it's 0.02. Might not be completely accurate. And Whitewater Solar is not a public utility, so the obligations and the statutes that apply to Whitewater Solar are different than to a public utility. And actually, I believe 196.487 applies to a transmission company, which is even a different standard and has a different statutory definition. Of which the applicant does not meet.
Right. So if you're looking at the definitions of 186.487, it's applying the statute to public utility, affiliate, and the transmission company. The applicant is neither of those. Is that correct?
Correct.
Your Honor, may I ask a question?
Yeah.
So
I'm just going to go off the record for a second. Sorry. Someone's just making, I think it's Sean, you're just making some extraneous noises. So I'm just going to unmute you for now. So if you want to speak, you just have to unmute. Okay, yeah, go ahead. Who had a question there?
Yvette Lassell.
Becca.
So what I was hoping to do is to have the applicant give its opinion on these, and then I'll give you guys an opportunity to respond.
Thank you, Your Honor.
Okay, yeah. I'm sorry if I wasn't, that's just what people expect. I'm sorry if you didn't catch that unspoken rule. So so we'll move on and have the applicant complete its presentation on that. So go ahead, Attorney Cahill.
Sure. So the second statute is 196.495, which relates to avoidance of duplication of electric facilities. That statute applies to distribution facilities, which doesn't apply to a generation plant like this. Next statute is 1.13, which is a direction to state agencies as to how to orchestrate their plans and land use, but it's not directly applicable to CPCN approval. 59.69 relates to local planning and zoning. And I think, as we know, under 196.491, that zoning authority is preempted by the authority of the commission to issue a CPCN.
Okay. And is there any applicability of 5969 to merchant power plants?
No. It is not. The local government authority is preempted regardless whether it's a utility or a merchant plant.
Okay, go ahead.
893.28 relates to prescriptive rights for certain utility facilities. It relates to transmission and electric lines, which in this case would not apply. The only generation tie line is about 740 feet, and it will be entirely on We Energy's property. And then the final statute that was referenced is 91.84, which relates to agricultural enterprise zones. And under that statute, there are certain areas that are recognized for agricultural preservation, and agricultural preservation agreements can be entered. There is a parcel that is within the project that falls within an agricultural enterprise area, but it is important that parcels that are within these areas, whether to enter into an agricultural preservation agreement is up to the landowner, and landowners can decide to withdraw their property from preservation agreements.
Okay, so just to be clear, you're saying there's a participating landowner whose land is subject to a preservation agreement at this point?
I'm not saying that they're subject to a preservation agreement. I'm saying they're within this one of the agricultural enterprise areas.
Oh, okay. So there's a potential that it could be.
Correct.
but it is or is not at this time.
But I do not know whether there is a preservation agreement. If there were, that landowner has the right to withdraw it from that agreement.
Okay, I see.
And so that would not in any way preclude the commission from granting a CPCN in this case.
And there's no obligation or this doesn't trigger commission jurisdiction. The fact that there's an agricultural enterprise area doesn't trigger any additional duty or evaluation criteria for the commission to consider in a CPCN, does it?
That is correct.
All right, so that's the applicant's opinion on adding those statutes. Let's hear from interveners. I think Yosette, you had a comment.
Thank you, Your Honor. I guess I'm back at a couple things. My first concern is that I have reason to believe that the application itself isn't complete for the merchant power plant. And I brought this to the attention of the PSC staff, and I'm curious why we're moving forward if we have a question on that. Secondly, I question if they are actually qualifying as a merchant power plant. Based on the definition I saw in the statutes and the information provided by the applicant during discovery and in their application, it appears that they don't have any intention to operate this plant. Rather, they have an intention to sell it, which means they seem to be more of a general contractor with an agreement with We Energies or WPS ahead of time and not a merchant power plant. So having some clarity on that and those statutes would be very helpful.
Okay, and did you have an opinion on the, is that 7? No, that was wrong, right? This was 6 statutes that were requested to add in to the
I do. I think the reason why I mentioned it, and I read some of the other interveners' positions on this, and they are welcome to jump in as well. I think we're concerned about this because of the lack of information in the application, meaning first of all, the interconnectivity agreement, which is part of we understand it to be a part of a complete application. We don't understand how this would be possibly providing reliable service if they don't have a way to hook up. One of the things that Attorney Cahill mentioned was talking about that this doesn't apply. They are connecting to a substation. And so that's one of our concerns. And we're also concerned about duplication of electrical because we don't see how this is all going to work out. They don't have the interconnection that they need. We're concerned, frankly, that We Energies perhaps purchased the plant in town just for the interconnection agreement and that they planned to take it down. And then all of us are going to be on the dime to pay for that plus this because of the way that the laws work. Now, this isn't my area to speak on in detail, but I do have some concerns. And I think that coming to an understanding of whether or not they actually apply or are allowed to be applying as a merchant power plant lends itself to the rest of these. Because if they don't qualify as a merchant power plant, then these things do, I believe, apply, sir.
Okay. Okay, and then in terms of the other specifics, no specific responses to the other statutes. Just want to make sure I catch all of your opinions.
I think some of the other issues came up because of the land use planning and the planning and zoning authority. We have concerns, and I have concerns about the fact that all of those rights are being just pushed to the side and that those zoning laws actually protect the citizens and that, again, they're being set aside. And we don't necessarily agree that that is constitutionally correct. And we do think it's relevant because we are citizens that pay taxes in this area and we all are expected to follow the zoning. We don't really understand I don't understand why those laws wouldn't be applicable and why they can just be set aside. You know, for example, if I want to build a garage because of the location of my home, I have to follow and be 170 feet from the center line to build a garage. They can be 65 feet from my bedroom with a solar panel. I don't understand that. So I do think it's applicable, and I do think we should have it in, because zoning laws are part of one of the issues, which is not interfering with land use. It's one of the statutes, and we should be able to argue those things. And I think they're relevant. That's why I wanted to bring them up, because that's all we have as citizens. We are all expected to follow those laws. Why would a public utility, or I don't know what you want to call these guys, I think that they are a construction company that's been hired by a public utility to avoid the law. And that's part of what I would like to argue, sir.
Okay. All right. Any response from the applicant?
I think as the commission well knows, the issue of a merchant plant has been addressed and decided on multiple occasions, and it's clear that the applicant meets that standard. Regarding zoning laws, legislature made a decision as to in what circumstances, what infrastructure is subject to regulation by the Public Service Commission and approval by the Public Service Commission, and in which circumstances local zoning powers are withdrawn. And this is one of those cases, and it sounds like the objection is to a decision made by the legislature, not anything for the commission to decide.
Okay. Yeah, so I want to address then the points that well, first let me ask if any other interveners have something to add to this.
No, this is Bob Platt. I would also say that there's some obligation on the part of the commission to have some recognition of the local ordinances and some respect for that in some way. And you know, so I don't know that it would be categorically removed from a list of consideration for that reason. You know, even if it were excluded, they could just bowl over it. There would likely be some consideration of the local authorities' regulations and concerns. So I would say it should remain for that reason.
Okay, anybody else?
Could I ask that the applicant reiterate what they said about the merchant plant question? I'm not sure if I just didn't catch it, or perhaps could he expand on that a little bit, please?
Yeah, hopefully we can get that from the applicant. Yes, so go ahead. I think we have to realize that I think people are not familiar with our process, and I think what Attorney Cahill's alluding to, and I'll have him explain a little bit more, but the commission has been faced with this exact question several times in solar farm cases that have been organized in a similar way. So we have situations where an independent power producer, which is what Whitewater Solar meets that definition under the statutes as an independent power producer, they fall under a certain process in the statute that we're following here, the primary one, which is 196-491, and that one, as an independent power producer or a merchant wholesale, what's the exact wording here? A wholesale merchant plant. Let's just be clear. So that's in the statutes. And well, let me just, I'm going to have you explain this, Brian, but don't worry. So definition in the statute, 196-491, that's one that's in our issues list, the standard common one. They define, the legislature created an entity called wholesale merchant plant. Now, we've had, this is 9828 CE 100. So we started with 9800 when we were dealing with these solar plant applications. We haven't gotten through 28 of them yet, but we've gotten through a number of them. I mean, I think at least 10 or more. They're set up in this way where a wholesale merchant plant is the applicant. And whether it's stated in the application or it's in press releases or it's filed later in another docket, a utility has requested to purchase the plant. either after it's approved by the commission or even before it got approval by the commission. And interveners have asked the commission to investigate that and decide whether the applicant still qualifies as a wholesale merchant plant. And the commission has stated that it is still a wholesale merchant plant and applied Chapter 196, 491 in a way that followed the applicant's their design in the application, that they're a wholesale merchant plant. And because of that, they're exempt from certain requirements. Now, because that's been done before and it's been litigated before, it's been in the courts, I don't feel qualified to change that designation on anyone's behalf in a specific case. I think that's a settled legal issue at this point. So regardless of the fact that the utility plans to buy this project or may in the future buy this project or has made some sort of announcement that it likes this project, it's irrelevant. It's not going to convince me that this is a utility project. Commission has been faced with that situation before and has told all of us that it still considers this application one of a wholesale merchant plant. So we're going to apply the laws in this case, recognizing that this is a wholesale merchant plant. So there are certain, so if that's the case, where you see statutes that apply to utilities, public utility affiliates, or other entities like transmission companies, those can't apply here because this applicant is none of those things by law. It's just when we can't change the law here. So those are the certain rights and due process that I need to balance and recognize when the law says something and we need to follow it. So that's one of them. So if that's the case, then certain statutes that make those references to different entities aren't going to apply. And certain aspects of 196-491 don't apply because the legislature chose to exempt wholesale merchant plants from those statutes. So the definition will show you that you're exempt from sub 2, exempt from 3MA. And then there's other sites exemptions within sub 3 of 196-491. This is the one you're going to be most familiar with when we get into the testimony. There's different procedures but the standards that we need to apply, there's certain ones that exempt wholesale merchant plants. For example, we don't ask, and we don't investigate whether the plant is needed. That is only if it's a utility plant. Then the commission has the jurisdiction to investigate the need for the plant. For wholesale merchant plants, the legislature decided it was okay if a plant gets built and is never used. There's no need for it. The commission does not have jurisdiction to deny an application for a wholesale merchant plant if it's not needed. What it can do is it can look at the impacts of the proposal. And part of that, as you'll see, deals with environmental factors. But one of the other exemptions to all CPC and all of these big projects, the commission has to consider the projects, whether it's consistent with a land use plan that's in the local within the local community. So if the community has produced and created a land use plan, a comprehensive land use plan, the commission needs to judge whether the project's consistent with that. But in terms of local zoning, there's an exemption for these projects to adhere to local zoning. So that's something the legislature has told us that does not apply to these projects. So we can't look at that but we can look at the comprehensive land use plan and see if this is consistent with the plan. I don't know why I'm not finding that statute here.
Your Honor,
So
it
let
is
me
my under-
just before you start, let me just point out, so we're looking at this sub 6 or paragraph 6. The proposed facility will not unreasonably interfere with the orderly land use and development plans for the area involved. So with that, you know, there's some, that's kind of, you know, ambiguously worded. I think that you could look at what that means and you can apply your understanding and present evidence and make arguments that this is not consistent with that standard. But in terms of saying you have to get a local permit, you have to, you know, this is subject to local ordinances, that's not true. So there is some review, there's some consideration for orderly land use and local development plans, but it's not applying the ordinances, the local zoning ordinance. So that's why we have to navigate these statutes in order to see what the commission has authority over, what's at issue in this case and what's not. So just as summary, for those reasons, oh, and I have one other point, I'm sorry. So in summary, for those reasons, the statutes that were being proposed by interveners don't apply in this case. However, the ones that we are applying and we normally apply do provide the opportunity to present some of that criteria, some of that those concerns to the commission without needing to, you know, invoke the statute. But remember, like reliability, the need for the project, that's exempt. These projects are exempt from that. The other thing I wanted to just mention was the completeness determination. So there is an actual process here by which the commission has to evaluate an application and then deem it complete. And we have done that already. So I had it up here, yeah. So I think this letter was filed in our case in this docket on November 13th, where commission staff, our engineering people had reviewed the application and deemed it complete. So in terms of moving forward with the case, the commission has already made that decision. So that decision's out of my hands, and it's something that the commission doesn't review when it's going through the process of evaluating the application. It's already been deemed complete. Now, completeness does not mean everything is in the application. It's all, you know, the four corners of the application is got all the information we need. That's not how the process works. There's still information that needs to be filled in and then gets evaluated, but the whole project gets evaluated on the merits. But in terms of triggering the process of completeness, we've already done that. And that's a decision that I guess I can't advise you as to what you would do about that. But our process is to proceed once we have that completeness determination. That's why we're here and doing this case. You know, I suppose if you would like to argue the case should not go forward, you'd need to ask the commission itself that question. But I'm bound by this letter and to move forward with this case. So we're going to do that. I'm not going to stop and you know, rethink whether we should be moving forward or not. So, you know, there may be other legal opportunities for you to make that argument, but I can't advise you about that. So we're gonna have to leave it there, unless we have other questions. So, oh wait, Katie, I see you had your hand raised. Sorry, don't usually look at that. So why don't we hear from Katie Nicola, Clean Wisconsin?
Thank you, Your Honor. I just wanted to add, just for the sake of clarification, that independent power producers don't only build solar projects. I think you might have that impression. And because they do build all kinds of power plants, and the same exemptions or exceptions to some of the rules apply no matter what kind of power plant they're building. Thank you.
And Bob, you had your hand up?
Yeah, thank you. I just want to go back to that description you had about some of the history of these things being approved of or and so forth. Merchant plant. I think a merchant plant presumes that you're able to sell it and otherwise it's just a fairly expensive artwork that's all over the neighborhood. The idea of it being a merchant plant is to sell it, and if something's to be complete, and I think they deemed it complete, we understand that there's issues, but down the road, don't you have to have a way of selling it? The interconnect agreement is not, as I understand it, applied for. It's not there. It's not part of it. We don't even, I don't know that there's necessarily capacity there. Don't know what the plan is. So I think there's a need to, you know, for a body like that to take into consideration all of these matters that, you know, this might not be able to be used at all for the merchant plant that it's designated to be. So I don't know if you had any thoughts on that, you know, from what you had mentioned before. It's not a complete merchant plant because you can't sell it.
Well, I'll get at my soapbox if you want me to. I have a lot of thoughts about that, but I'm not going to share them with you necessarily. But what I can say is that Act 9, 1999, is what basically we're getting all the major changes in energy planning occurred with that statute. And prior to that, Commission had authority to basically, it was a command and control system where we reviewed the entire energy system in the state and we approved projects based on need for for all utilities. And we went through the process of, you know, gathering information and evaluating them and making sure that what was being built was needed. For various reasons, some of them was argued that we were facing shortages of energy and that the commission, some people argued the commission was slowing down the process of developing energy facilities. So that power was taken away from the commission, the power to evaluate and really scrutinize these plans as a whole in kind of a statewide system. And this new statute, this new system was enacted. So this system basically does not recognize what you're saying, the concerns you're saying. It says if someone has the money and wants to put up a power plant and it meets the requirements, it should do so. Whether it actually gets used or not is not what's considered in this statute. You know, as far as I understand it, the motivation for that was get some more plants built. We need them built quickly. We need power now. Let's not slow things down. So the fact that maybe someone wants to take the risk and build a power plant and put it on the market, that was deemed reasonable, you know, setup for Wisconsin. So and the consequence is that you're now faced with this conundrum where we do have a plant. Now, that's not to say that this plant won't be built and won't be used and won't be, you know, a good addition to the energy mix here. I'm not saying that. I'm just saying that in terms of the process and the frustration you're facing, that's built into the process, and that's what we have to follow. So yeah, anyone else?
Your Honor, what about the pending litigation regarding, I think it's Koshkonong? This very issue, I believe, is in appellate court right now. Isn't it?
Yeah, I'm not actually well versed in the appellate, the status of the appellate cases at this moment, but that really can't stop us from proceeding with this case. In fact, there's the statutory deadlines that get triggered in this statute so that if we do not make a decision within the time frame, the application is deemed approved. So we can, and what I would say is that the best bet, I think the best opportunity you have is to work with the process and try to get, have the commission evaluate the project on the merits according to the standards. And the commission can modify things that maybe it feels doesn't meet the standards. So that could be beneficial to your situation. But in terms of derailing the process, especially, and right now, though, all the orders that we issue go into effect and are valid until overturned. So even Koshkanon, although it may be in court, the order stands and it's valid. And I don't know the extent that they're building it right now, but they could move forward with that based on the valid commission order. So, yeah, anyone else?
If I heard Your Honor correctly, if we have evidence that the applicant has provided you with false records and it doesn't have a complete application, the thing to do would be file a motion with the commission?
I'm not going to advise you on that, but yeah, I can't really give you advice on that kind of situation. Just the scenario itself, I don't even want to recognize necessarily the hypothetical, but hopefully that's not the case. But yeah, my authority extends to administering the process. So right now the process is ongoing and I'm in charge of it. If the process was to stop, the commission would have to tell me to stop.
Thank you, Your Honor.
Okay. So with that, I think I've heard enough to decide that our issues will remain the normal issues list. Like I said, you have to read that statute, especially 19649, and see what criteria that can be applied to the application that you would want to introduce evidence on. And all the other standards we're citing here would be something a party could offer evidence and make arguments about. So, I don't know if let me just check in. Let's go off the record. How you doing, Debbie? Do you need a break with?
I'm good.
You're good? Okay. If you're good, then I'm good. So we want to discuss the schedule and
On or off?
Oh, let's go on. Thanks. Yeah, so let's discuss the schedule now. We have what was proposed originally. I think that's off the table now. So I'm going to switch to a different document. And I think that first of all, I appreciate the applicant for agreeing and recognizing that there is some time in the front end here to move our applicant direct back in the schedule. And this you might not be able to see this very well, but I'm gonna maybe just zoom in on some things. Document here is something I created which attempted to listen to what people were saying and Karakant had kind of had shared some of the back and forth, the meet and confer. So I was kind of keeping abreast of what was happening, but I know that we had some, I was looking at basically starting at February 19th. That was kind of the new start date for testimony. Someone's trying to get in. I just have to, hang on, just off the record for a second. Oh, it's check. So I was looking at a couple of different things. I think someone had mentioned Koshkanon was a case that had a good schedule. So I looked at that one and I didn't, if that is 9810. Yeah. And so this document just shows you like the date intervals between these filing dates. And I kind of came down with a new proposal, which is on the very end of this document. I think one thing I was encouraged about was the May 20th hearing date. Once we had some more time in the front end, I thought that would provide enough time for testimony to come in. The other dates are really sort of mechanical, and we can adjust them if people need more time. But I think basically we see that after the hearing, there's these transcription kind of correcting documents. They're not usually not very involved. There's not a whole lot to do at that point, so we don't give that much time. But we can give some more. That's not really an issue. It's not a big deal. And then the brief dates. The important thing is from the when you look at the interval between the hearing, the party session, and the initial brief. That's kind of the number of days you want to pay attention to, and then the days in between the initial and the reply. Now I'm not sure. I was hoping to give you guys so looking at the Koshkanon schedule. It actually gives you the end date for the reply brief was would be now, if you apply it to this case, would be July 7th. And the reply brief date that I was thinking about would actually put you a little bit past 4th of July weekend, a little bit more, could be July 14th. So I was hoping that would be a benefit. But so in the end, it looked like using Koshkanon didn't get you a whole lot more than what I was proposing. So having said that, though, I just wanted to check in with staff and see if they had any other ideas about the schedule at this point.
Yeah, Judge Newmark. This is Kara Coombs, attorney for PSC, and I have been discussing with staff a little bit more, and it seems like there might be some flexibility with the reply brief to kind of push that to like July 31st. And we've been working on kind of a little bit during this, we've been crunching some dates. We have, I think, a schedule that has a little more flexibility for testimony and rebuttal, pushes the hearing out a little bit. But I wasn't sure in what way you wanted me to share that with you.
Well, why don't we just let's go off the record and just collect those dates.
Okay.
And I'm going to try to there we go. So let's just do this.
Just let me know when you're ready.
Thanks. So now you're going to put some dates down, but just remember there are other hearings scheduled. So I'm going to have to see how that works with your.
Right. This is all, we haven't vetted it with other hearings. It was just something we were trying to come up with this morning.
Okay, I just want to warn everybody else.
Yeah, right. Just if we add any more flexibility.
Are we back on for?
Yeah, well, actually, we could be off. Let's just collect the dates and let's collect the dates.
So the applicant's direct would stay the same, the 219, because that was what they agreed to. The intervener and commission staff direct, we had that at 422. And then the rebuttal at 520.
Oh, a hearing kind of.
The rebuttal at 612. The Marata testimony and replacement exhibits, I did that. I had 711, but I wasn't sure because I know it's supposed to be so many days kind of before the hearing.
At least 2 days before.
At least 2 days. Okay. And then, sorry, not 711, 71, excuse me.
701.
Yeah, we had the hearing, the party session at 7:02. So maybe then the errata needs to be changed just slightly. Because Clean Wisconsin, they had a conflict kind of in the last part of June. So then we moved the hearing out to July 2nd.
Okay, well, go ahead.
Yep, the public session we still had as TBD. And then the draft transcript at 7/7.
And is that so you're giving
July 4th is Friday.
Okay, got it.
So I did 2 days, 2 working days from the hearing. The exhibits offered and received at the hearing, I had it 7-8. And then the revised testimony 7-8. The witness verification affidavits at 7-8. The proposed corrections to the draft transcript at 7-10. Had the objections to the proposed corrections at 7-14. And then the initial brief was at 7-24. And the reply brief was at 7-31.
So that's pretty short.
Yeah, we can't. Yeah, we can only see the one column.
Sorry, which one?
But I think maybe we can't see the other part that has what these dates are tied to.
Right. Yeah, I don't know if well, let's see what I can do.
Yeah, it's okay. I just want to let you know, we just see the dates. You see the two columns with the old dates and the new dates. Yeah.
So this is the new schedule.
Yeah, new.
Okay.
And again, this was just something we were kind of plugging in with drop dead date for the reply brief around August 1st.
Okay.
So,
So that's significantly more time. So I do appreciate giving people like on the testimony, especially. Okay. I want to check. So let me just stay off the record for a minute. I want to just check my schedule. Okay, so that first week of July, maybe. Oh no, actually, might work. July 2nd would work. And so that's good. So yeah, that would be okay. The other date, I think the date that may give people some heartburn is this initial between the initial and the reply brief. And I think so we do have, how many days are we looking at between the 2nd? 22 days with the 4th of July week. Yeah, I mean, I think if we probably just want to, well, we can ask parties. We're going to give you guys a chance, but I think we need to massage that dates. But otherwise, let's hear from people about that. So can everyone see better now the screen share? Just
yes, I can, please.
So when we hear from the applicant, any comments on the proposed schedule?
Are you still off, sir?
No, I'm not. Let's go back on the record. Okay. So thank you for that. Yes, all right. So staff did provide us with a new proposed schedule, and so we're just going to get some comments from parties at this point. So let's start with the applicant.
I recognize that the back end of the schedule gets very tight in terms of the briefing. Seen schedules that tight. So I think from our perspective, that's doable. The hearing date is the sort of the first date that I am available due to a trial the second half of June. So I know would be unusual to have the errata due earlier. Like if we can push that up, that would be helpful. Since I will be unavailable for that purpose. It poses, I recognize, some difficulties for my client in terms of preparation for the hearing because I'll be unavailable. But if absolutely necessary, we can make it work. Our strong preference is for the May 20th date that was initially proposed. And that's part of the reason why we accelerated our direct testimony to the February date.
So that's what you get for being nice. Okay. Well, I heard a lot of it is doable in those in your statement there. Let me see. Well, yeah, the errata date, it does not need to be, it could be any time in between surrebuttal and the hearing. I don't think it's, and I can explain a little bit about what the errata means. So I think some of these maybe people weren't too sure about what we're asking for, and that's totally fair. So because testimony is all filed in writing, if there's any errors that you recognize, mistakes, transpositions of numbers, things like that, part of the requirements of participation is to file a correction document. And really that should be filed as soon as you find the mistake. So, if on direct you said, I live on, West 197, but it was 198. That's not really too big of a mistake, but we want to get things as accurate as possible. It'd be wise to file that correction as soon as you know. So it could be way before, the next round of testimony. Actually, it'd be best if you can file corrections before the next round. I don't require that, but just for everyone's benefit. So the way you would do that is you would file basically like an errata statement would be like, it's kind of like a proofreading statement. Like on page 10, I said 198, but it should read 197. And that's all you have to do, just so we know where the mistake is and you identify the correction. And then later on after the hearing, that's when we do the revised testimony deadline down here. That's when people are supposed to file the new versions of their testimony with the corrections incorporated. So there really shouldn't be a lot of surprises. By the time we get to that point, we should all know we definitely should know what those corrections are and what to expect. It's just filing it by that date. And like I said, because there's so many people here and so many people are new, we could give more time for filing. That's just more of a technical thing. But it's just so the commissioners, when they get your statement, they see the corrected version. They don't have to wonder which version am I reading and what's the correct number. We give them the final version only. So this way they see what they're supposed to see. So, so the errata, when does your trial start, Attorney Cahill? When would you like to move that errata date?
You're on mute.
I'm on? No.
No, I am.
Okay.
Sorry.
Oh, no.
June 18th would be great.
Okay. I think that should be plenty of time. And if something, this is not, I mean, if you want to, that's fine. You can file yours. If something happens and people have to file something late, as long as it gets, we can be flexible, but let's set it at June 18. And that'll at least help with your process there. Yeah, I mean, I'm hoping that'll work. So let's just collect any other comments before we make any decisions. Any other interview?
Your Honor, I have a question.
Okay.
So part of what we're gathering, me and some of my friends that are helping me, is data, right? We're gathering some data in order to argue various things like land use or public interest, et cetera. And when would be the latest on this that we could submit that? Like, is that something that would have to go into our direct? Could you tell me like when would be the last moment I could enter that? That would be really helpful. And my second question is, for these documents that we have to review and check, can you just give everyone an idea about how many pages of reading that is? Thank you.
Okay, so let me get that second question first. So in terms of the errata, is that what you're referring to?
You said there was a document, maybe it was the transcript.
Okay, yes.
Something that we had to, documents we had to review.
Mhm.
I mean, I've never seen these things before. I'm just wondering how many hours I need to set aside to read it. I mean, I wondered if other people also wondered for those of us who are fresh to the
Yeah.
process.
Okay, so yeah, maybe it's, let me give you that first. So what you see on the schedule is direct testimony, the rebuttal, and the surrebuttal. Those are the main dates you're going to be looking at. Errata, in terms of reading what you need to read for an errata, you only need to read your filings. So you're only authorized to say, I made a mistake on my direct. It should be something else. And then you want to file that. So that's really depends on how much you write, is how much you're going to have to read. Then when you move down to the corrections to the draft transcript. So this is kind of more of a courtesy. So the years I've been here, we never really made that a set process. We would have someone transcribe the hearing, and then we put the transcription out, and then, you know, eventually, or without fail, someone would say, "Oh, I didn't say the word. I said the word to, TOW, not the word to, TO. Can you correct that for me?" And we'd have to go through this process because there was no correction procedures. We would then decide whether we're going to do it or not, and put it in an errata sheet at the front of the transcript, or file it in a different box, or it made all kinds of confusion. So what we're doing now, how we've done it now for many years, is to issue a draft transcript, have everyone look at it, and then write back to us and say, you know, before you make a final version, can you change these things? So kind of most of the corrections I ever see are just they're grammatical errors, they're spelling mistakes. I mean, Debbie does a great job. So she's hearing what you say, she gets it in there, she takes very good care to record what you're saying. Now, there are some times where you say the wrong thing, and it's to the benefit of all of us that we correct what you actually said. So that's pretty rare, and I don't like to do that. You know, it has to be a really important situation to do that. But when it's important to do, I will allow someone to change what they said at the hearing. But what you have to do is you have to propose it, and then everyone gets to see it, and then they can object to it if they don't like that change. And it's fair because it's something that if you didn't say it at the hearing, you really shouldn't be able to change what you say. So, but I do recognize that sometimes it's important to do that, so that we provide that opportunity. So if someone says, you know, I'm trying to make something up, but you know, it's this area is subject to high rains, but they meant to say high winds, and that has an impact. There have to be a debate on whether it's fair for you to change that testimony, right? Because that might make a difference, but parties didn't get a chance to hear you say high winds instead of high rain before at the hearing. So if you wanted to propose that change, you would do so when you're proposing corrections, and everyone else can see that and say, oh yeah, that makes sense. Everyone really knows you meant high winds, and we didn't want to ask you a question about it. It's okay. And there's no objections. Or someone might say, hey, you should have said that before. That raises all these issues I didn't get a chance to argue or investigate. Then it gets tricky. I may have to deny that change. So that's what that process is for. That's really the real reason why it's there. But it also just gives you a chance to make those minor corrections. But you don't have to make those corrections. I think everyone's going to understand if you say to, and well, maybe TO instead of TOO, maybe easier. People understand that there's no real confusion necessarily there. So, or they can understand it if they read it. But so it's up to you how much you want to dig into that. so like the applicant may want to read the entire transcript and try to and find corrections on everyone's testimony, but for a party, they might just want to be interested in what that particular party said and make sure that their statement's correct. So there's no obligation to do it, and you may have, resource time commitments that you can't follow through with that, but the opportunity to do it is there. So it would really be up to you to decide how much you want to do that. Having said that, it's the best practice is to have the final transcript in your hands before the initial brief is due, because you're citing to the transcript when you're writing the brief. Now, if you only have the draft, you probably do a pretty good job writing the brief. The transcript's not going to change very significantly. If it does, we would have to deal with that. That's okay. But you have plenty of time here between the initial brief, objections to the proposed corrections. So, after the hearing, July 2nd, and then, proposed corrections July 10th, that's a lot more. That's the standard amount of time, right? But we have the holiday, so you're given more days than usual. But yeah, that's just to give you a sense of what all that is. The other thing you should know is, so we have these filing matters that we order in these cases. So I'm just going to show you this. On the back end of the notice of pre-hearing conference, you've got this document. And I'm going to reattach this to the pre-hearing conference memo as well. Now, at this point, we can talk about making changes to this, but once I issue the order, then whatever's in here is going to apply to the case. So what you have here is all the requirements, how to file, what we want you to file, when to file. There's all kinds of details in here. But what you want to answer your question, Yvette, is what the heck is this direct rebuttal, surrebuttal? So there's a definition here, and I'm just going to zoom in on it. Definition. So it says rounds of written testimony are defined as, so you have direct. This is the opportunity for each party to present its position and produce evidence to prove the facts needed to support its claims. So it's really the main thing you want to say and all the support you want to put in. So we give the applicant the first round of that. I mean, most of their information's in the application. Now, they may need more to say. There may be some additional stuff, or they may want to frame it a certain way. So they have their witnesses presenting what they found, what the application says, their process for getting the information, for producing the application. But that gives interveners and commission staff more time to look at the application and what the applicant says about it. And then now it's your turn on your direct to put all your case in on direct. So if there's a study from somewhere, if there's if you have an expert you want to sponsor who knows about whatever it is, soil compaction or stray voltage or something relevant to the standards that were on the issues, you can sponsor them indirect. They'll file their document with their testimony and then their supporting evidence as exhibits. All of that should go in on direct. And now there is an opportunity for what we call supplemental direct in case there's a reason, there's good cause that you didn't get that in on time. And I'm not showing that here. So you'd have to actually you have to file a request to explain why it's coming in, late, technically late. So for example, if you ask the applicant some questions and maybe there was some controversy about that, or maybe there was just a reason for a delay to get those answers, you may not be able to get that in on your direct. So we can accommodate that. We can move on and survive that. by filing supplemental direct. And then we'll have to discuss whether we need to adjust some schedules or maybe add some additional rounds of testimony or not. It depends on the situation. So, but if you get your direct in and it's all good, your next round is rebuttal, which is where you're then responding to the other party's direct and commission staff's direct. And you're not really supposed to bring up new stuff unless it's directly responding to what they said. So if you say, well, they forgot to say this thing, and I want to talk about it, that might be okay. I mean, you might end up getting into a little bit of hot water with something like that. We'd have to then see if that's okay or not. But for rebuttal, you're basically responding to the direct testimony, and you should be citing to it. So if you say, the applicant's witness A said this, I think that's wrong. So you have a direct connection to the prior round of testimony. So rebuttal is the same thing. You're responding to rebuttal. So the idea is that in the end, what's being presented, the controversies or the misunderstandings or the adverse claims that people have should end up be getting more and more succinct and specific. So then, Sir Rebuttal, you kind of whittle down the main ideas of what the controversy is about. And in fact, I usually, when commissioners ask me, which they don't usually do that, but when they ask me, how should I, review these big records, I always say read Sir Rebuttal first, because that's where people have had the chance to really think about it and parse out all of the details and have come up with the really big controversies in the case. And then when you know what those are, you can read the rest of the record in a much different way. So you've seen what really people are arguing about. But it's important that direct has everything in it that supports your claim, because the commission needs to make its decision based on what we call substantial evidence. It's a legal standard. So there has to be enough evidence that makes the decision reasonable. So most likely, if you're presenting an argument or presenting a position that the commission's going to accept, there's going to have to be evidence. Most likely, they're going to find that evidence in your direct, all your, really the basis of why you think this is right. So most likely, direct is your biggest document, and then it's going to get, most cases, it gets shorter and shorter because the controversies become more specific, and they become more, pointed at certain controversies. It's not just an entire review of the whole case. It's whittling it down. So, did that help at all?
I think that was very, very helpful. Thank you so much.
Good, glad. So then, just one other thing about this whole facilitating matters. Like I said, it's got a lot of details in it, and this is kind of our expectations for parties, which is why, I was saying, you sure you want to be a party, because there's all this stuff you got to do. But if you have questions about it, your first point of contact is the commission staff attorney, and they can funnel questions to me if they don't know the answer, or there's some sort of trick to your question. But there's also examples of all of these documents on IRF in other dockets. What I would say is you'd want to look at the received documents I've received on the record, because those are the ones I've asked for the corrections to be filed. So if some filings are, we had to be redone, so you don't want to use those. And wasn't really prepared to do this, but let me see if I can just show you a quick version here. So I'm on the IRF system, and you're going to get familiar with that. So just back up one more. So I'm just searching a docket. and all the well, let me just look into testimony received and exhibits received. Go. And so now you can see, sort by this, you'll see all of the documents in this, what was this, Maple Grove Solar. So MGS was the applicant, and so they're filing using our conventions. And actually, this case, everyone did a really great job. So they have the convention set up. They have all the documents, the testimony and exhibits filed. These are the ones I've received. So now it's really easy for the commission to understand what they need to read for the case. So you look at one of the direct documents. This is kind of the standard look and feel that we're going for. And all of this is described in the facilitating matters order, that document we were just looking at. But I would suggest you go and look at some examples, because that's the easiest way to really understand what we mean by all those requirements. But you'll see, like, there's line numbers, you're asking the question, you're getting the answer, you have the exhibit labeled a certain way. All that stuff is in the facilitating matters document. So again, if you had questions, Kara is your first point of contact, or she can ask me questions based on what issues you might be facing. Also, in terms of filing, IRF is pretty simple, but people get stuck on it, and it's not super user friendly, I guess. So I actually look at it in a different way than the members of the public do. So, but if you, the important thing to know is that when we set a deadline, that's when you're supposed to file the document and serve it to the service list. So you'll want to email everyone the document, as well as filing it on our system. But if for some reason the IRF system isn't working for you, at least email it to everyone, because that's really the critical thing for timing, that everyone who's supposed to get it at a certain time gets it. The public can wait a day, an hour. I'm okay with that. We'll figure out how to get your document on IRF. But the parties and staff should be getting your documents. If you're having any trouble, email it first, and then contact. So records management has contacts that you can call them. They'll send you an email if your document gets rejected. But here, right at the top of the facilitating matters document, you have the phone number for records management. Okay, so so those are the main things I wanted to review there. Any other questions about? Oh, Sheila, I see you had your hand up. Sorry.
Judge Newmark, would it be possible for you to go back to the very first document that you had put up regarding the state statutes and PSC admin codes that the PSC would be considering?
Mm-hmm. Let me clear this up a little.
And I do have a question, if I'm able to ask that currently.
Well, I'll hear it. Yeah, go ahead.
I noticed that the electrical standards and codes weren't listed, and I was wondering who is going to make sure that the applicant complies with those electrical codes?
Okay, so PSC admin 111, not our. Let's see. Let's just go off the record for a second. Yeah. Hang on. Let me.
If you want me to state those for the record, I can quick.
Oh, you have the codes. You want to? Okay. Yeah. Let's.
I do. The code that I'm questioning.
Okay. Yeah. Let's do that. Okay. I'll get on the record and just state the codes you're interested in.
It would be IEEE standard 519-1992
Also Rule 9.2D as in dog, which is current in ground conductors. And the third would be Rule 215B as in boy.
And those are all IEEE standards?
The National Electric Safety Code and the American National Standards Institute codes. I know they're the state requires that they be followed. My question who I know the PSC won't oversee that, but my question is who will make sure that the applicant will comply with those in addition to all of your other statutes and codes that you have listed there.
Okay.
And then if the applicant is not willing to comply, I would ask that they consider withdrawing their application. Thank you.
Okay, great, thanks. Yeah, so I don't know if I can tell you, I know exactly what those codes are. I know that the commission does regulate, let's see, I guess it's more like not utility necessarily, but large electric facility safety codes. It's not PSC 111, I don't think, but I'm assuming it's incorporated somewhere in the in either the application or the standards that we apply. I'm hoping maybe we could have someone from staff chime in on here. Yeah.
Judge, could I interrupt? I was just looking at what you typed and the codes are incorrect. If I could correct those real
let's
quick.
go off the record and do that. Yeah. Go ahead.
Okay, the first one you've got, it should be 519 instead of 591 dash 1992.
That is an outdated version of those industry standards.
Okay. And let me just get the ones that you think are correct, Sheila. There was 1, 2, was it
92 D as in dog.
Okay. Okay.
And the final one was 215 B as in boy.
Okay. And the 12 still is correct. Why 12 for some reason?
No, there's no 12.
Okay.
The first one should be 1992 at the end. The 2 is missing.
There we go. Okay. Yeah. Okay. So why don't we? So Attorney Kale, can you talk to those? Is that something you're prepared to discuss? Okay.
Are you still off talking?
No, let's get on the record.
Okay.
So typically the standard decision from the commission includes a requirement that the facility as approved comply with the National Electrical Code and the National Electrical Safety Code, along with Wisconsin Administrative Code, Chapter PSC 114, which is the Wisconsin Electrical Safety Code. The NESC 92D, NESC 215B are therefore wrapped into the commission's order. So that's, I don't know if there's much of an issue there. The IEEE is an industry standard. I don't know that the commission has adopted and do not believe therefore it would be appropriate to apply that, but I can't say that with certain whether the commission has adopted that or not as a standard.
Okay, because we just cite National Electric Code. We don't.
Correct.
Specifications. Okay. So it looks like that's something that we will consider. And although we don't cite PSC 114 in the issues list, I don't see why we couldn't just add that to the issues. Since we're citing 111. Because that incorporates the national code, does it not? It's just odd that we actually require that compliance, but we don't make it an issue in the case. So let's just go off the record for a sec. Anyone commission staff can talk to that point? And I don't know if like we have an engineer on the line or.
So, Your Honor, if I may, I would say that
we're off the record, just so you know.
Yeah, one of the. Oh, give me 1 second.
Yeah, yeah. So just off the record, just so you know, so we do have so we do regulate these specific standards for like the electrical code. And if we typically make that incorporation in the order that the commission, if the commission is going to approve the project, it does so on the condition that the applicant follow those standards. So that's our normal process. And we haven't put this as an issue, specific issue in the case. So, I mean, I guess I don't have a problem adding it in or just working on the understanding that we will make it a condition like we usually do.
Your Honor, it looks like intervener Margaret Platt in her public comment did bring up those same things that Ms. Williams brought up. She brought up those pieces, those 3 electrical issues that were just brought up.
Okay. So that was in this the EA scoping comments. Is that?
That is correct.
Referring to? Okay. Chang, can you hear me? See, you're connected.
I'm not sure if he's
He's paying attention.
still live.
Your Honor.
Well, yeah. Who's that?
This is Andrew Kell with Renew Wisconsin. If PSC staff aren't able to chime in, I could provide some insight.
You have the background, I'm sure. Yeah. Let me have you make that statement on the record if you don't mind.
Sure.
All right, let's get on the record. Go ahead, Andrew Kell. Do you have any comment on the safety code incorporation?
Yeah, thank you, Your Honor. I'm just looking at the decision matrix for the last case that the commission considered in Maple Grove Solar. Issue 6 in that decision matrix has a very robust list of standard conditions that the commission makes in ordering the construction of these projects. The conditions go through A through X, and condition H lists that the applicants shall be in compliance with the National Electric Safety Codes, as well as Wisconsin Administrative Code, Chapter PSC 114. That's all I wanted to share.
Thanks. Appreciate that. Excuse me.
I guess to that point, it becomes unnecessary to list all the sections and state them as an addition to the issue list, because there are dozens of sections to the National Electric Safety Code.
Okay. So yeah, we're on the record. Yeah. Yeah. So what I can say is, you know, I'm not going to risk adding it to the issues list. Was it Sheila who's asking the question? But I can say that this definitely is relevant to the commission's decision because, as you can see, we do this order condition that relates to the National Electric Code. So it's a fair issue. And you know, if you wanted to include some evidence on that or make arguments about compliance with with these items, that's perfectly appropriate, and you know, we'll accept that as your testimony, and you can argue, you know, how those standards should apply, and what you think the commission should do about that. But it looks like your request will definitely be addressed by the commission, that the standards will be applicable to the project. The commission will make that a condition if it does approve the project. So you know, if you want to provide evidence as to why, and to make sure it, you know, it has more you know, robust reason for doing that, feel free to include that in your offered evidence.
Your Honor, is I didn't see Miss Williams as an intervener.
Yeah, I don't know who I might be getting her name wrong. Is it Sheila Williams? No, I thought I saw her.
Are you off while you figure this?
Well,
I don't care.
Yeah, I think you're right. I don't see her on the list. Maybe I failed. I recognize the name. Maybe I failed to put her on the list. Sheila, can you come back to us here?
Yes, I'm here.
Okay, great. Yeah, so I guess, did you hear what I was talking about in terms of the issues for National Safety Code?
I understand that a prior approval for, is it Maple Grove, that there were electrical code contingencies that the applicant was required to comply with. But I did not understand who would actually be responsible for making the applicant apply or comply with the standards. Which body would actually be responsible for compliance? I doubt. Would that be the PSC?
Yeah, I don't know if I can explain that to you here, but if it's our orders and in the condition of the order that we're issuing, you know, that's one way of enforcing the compliance, would be to ask us to enforce that provision of the condition of the order. But I don't know if I can really give you specific advice as to how you should go about doing that. But certainly, if it's a condition of our order and it's a rule, you know, you could complain to us for that, to investigate non-compliance. And there may be other ways that you can that those rules and conditions can be enforced. But from what I know about our process, a complaint would be one avenue for doing that. Yeah. But in terms of the issues list and the presentation of the issues in this case, what I was saying is that you can go ahead and include that in your presentations, even though we're not going to specify it on the issues list. I think it's incorporated in the process and our practice that we include that condition in any approvals that we've given in the past. So all I'm saying is that feel free to talk about it in your evidence when you present your testimony. Did you understand what I'm saying? Okay. So the other question I had for you then is, don't see you on the list of interveners, and I'm not sure if that was an omission on my part or what the case is. So if you could help me out understand what's going on there?
I'm not really certain, why I'm not on the list.
Yeah. Okay. Did you file a request to intervene?
I'm not sure. I'm working on several of the cases currently, and I'm not sure, if I did for this one or not. So I apologize.
Okay. Okay, let's go off the record. So that does create a little bit of a problem. So I'm not sure. I know I've seen your name before. So were you involved in what case did you intervene in?
Currently I'm involved with the 9809 CE, the Town of Harmony, and the Town of La Prairie one.
As in, okay, but you didn't intervene in that case, did you?
No, I did not.
Okay. And see. Yeah. Yeah, you didn't intervene in this case either. So so without a request, we really can't have you involved in the case.
Down.
So let me check with the court reporter. Are we on the record or not? I can't remember.
You had me off, but I'm talking to my dogs because they're all getting excited.
Okay, yeah. Sorry about that.
No, I'm sorry that I thought I was muted.
Okay, so let's get on the record. Yeah, so we had a question from Sheila Williams at the pre-hearing conference here, and we answered that question. But then Attorney Cahill did indicate whether and asked the question whether this person had requested intervention, and it looks like I'm not seeing a request to intervene here. So what I'm going to do, actually, Sheila, I mean, do you live in the project area?
I live just outside of it, but not directly adjoining the project area, no.
Approximately 20 miles, Your Honor.
I'm sorry, I didn't catch that.
I believe she's about approximately 20 miles from the project area, so I question whether there's a substantial interest involved.
How do you know that?
I know what her address is based on comments filed in another docket.
Ah, okay. All right.
Yes,
So,
that is correct.
okay, thanks. So what I'm going to say, we do have a very large number of interveners currently in the case, and who are, who own property that's abuts or is very close to the project. So given that we haven't received a request for intervention from you, I'm not going to allow you to participate as a party in this case. I think the substantial interests will be of people who are closer to the project are the ones I'm recognizing as for purposes of having a right to intervene. And in terms of permissive intervention, I think we've certainly covered landowner interests with the large number of people currently intervening in this case. So I think to allow you in would be duplicative and not helpful to address the issues that the commission's going to need to review. We're going to rely on the interveners we currently have who have met the requirements of intervention and followed our process. So I thank you for joining and your interest, but I'm not going to allow you to participate further. Maybe we'll see you in another case where you have a closer tie to the project. And so I do appreciate you joining us, but I'm actually going to have to ask you to disconnect because we are not the only people who are participating at the pre-hearing conference are the parties. You can feel free to watch the live stream in order to observe the pre-hearing, but in terms of participation, we're going to have only the parties involved. So thanks very much, and I'm going to disconnect you now. Okay. I think she's gone. All right. So, but having said that, I think she made her point, and you certainly, anyone can argue that conditions be met by the applicant in terms of National Safety Code. Commission staff will include that as a condition to approve the project if it wants to approve the project. That's a standard condition it includes. So we'll allow evidence based on that. So anyway.
So you won't, you're not going to put it on the dot, you're not going to put it as an issue, but it is something that will be allowed?
Yeah, I think that's fine.
Is there, just out of curiosity, is there any reason why you wouldn't put it on as an issue? Does it open up too much stuff, or what's?
Yeah, I think, this is so the issue that we have, it's what we've kind of honed in that staff has used for years. And I'm not sure if we cited, for example, to the Wisconsin code, the PSC code 114, it really does bring up a lot of stuff that really isn't applicable to, even construction projects. It's a whole service rules. And so I'm not sure, I don't really think we have a lot of time or really the energy to kind of parse that out at this point. And so what I'm doing is I'm saying I'll allow it, and you can just, rely on that when it comes to issues about electric standards. Those issues are acceptable, and the commission does include them in the order conditions. So anything related to that should be fine. I'm just hesitant to cite like we're doing here. We have PSC 4 and PSC 111. I think that to add PSC 114 is just going to bring in a lot of things that may not be applicable, and we may end up just arguing about it rather than just getting to what we want to do, which is this specific item. So we can just rely on that instead of trying to figure out all the details at this point.
Okay, thank you.
Yeah. All right. Any other issues we need to discuss? I think we've gotten through a lot of it.
Your Honor, I think one of the reasons why I'd listed 59.69 was because it states the development plan shall serve as a guide for public and private actions and decisions to assure development of public and private property in appropriate relationships. And I just wanted to make sure that I will be able to argue that as part of the land use aspect and public interest.
Well, I think you can relate it to what is it called? Organized land use plan? Is that I don't know if I wouldn't cite to that, but I think you can speak to land use and how and the project's compatibility with land use plans. So I would say follow statute 196-491. That's really your go-to for the applicable standards when it comes to what the commission needs to review for this project. So there could be some overlap there. It all kind of depends on what you write and what the applicant thinks about it, and we may need to parse that out in terms of any whether it's relevant to the applicable statutes, but the specific statute 5969 is not applicable. So you just want to keep that in mind while you're drafting when you're making your statements. You want to tie it to the applicable statute, and I think 196-49 does speak to organized land use planning. The phrasing is escaping me at the moment, but I think you know what I'm talking about.
Yeah, I'm with you, Your Honor. I did have one other question. I know we're kind of swinging between the schedule and the facilitating matters, but I did have a question, and I think I mentioned this in the meet and confer, but it seems like there's some words such as orderly land use, undue adverse impact, adverse health effect, individual hardship.
Yes.
Material adverse effect, interference in orderly land use, public interest, unreasonable, and Your Honor mentions substantial. And what I noticed in the statutes as I read is many statutes in the state have definitions of what those words mean. And it seems like the crux of the argument is, as you said, to be able to show a substantial impact. And I'm asking this as a person who has reviewed quite a few of these. As you can probably tell, I've been doing some reading. And my question is, what, short of me going and getting a JD, where are we supposed to decide when we have shown the PSC a substantial amount of evidence? I mean, where's the bar? And is there even one in existence that we can meet? I mean, do they have a rubric that they use that could be shared with us so that we, I understand that part of law is the game of, oh, go find this, etc. But at the same time, is there an achievable bar, or is this just an exercise? And I don't mean to disrespect the court. I just wanted to get that question out there.
No, it's a great question. So first of all, I can't give you legal advice, and there is no definition for those terms. I don't think any of those terms that you cited are defined in any authoritative way in terms of I can't think of any, dictionary of those terms that might, I guess there is a dictionary of those terms. A legal dictionary may be your first point of contact, actually. But besides that, in terms of specifically applying those standards to this application, what you're going to look at is our past orders and try to figure it out from what we said in the past and in prior decisions. That's where, having a lawyer really does what really is in your best interest. That's someone who can really hit the ground running to be able to analyze what the requirements and what our standards are, how to apply them to this case, what evidence would be needed, what would persuade the commission. Those are the kind of things that you would look to our past orders and really do some legal research into. So, to say that, all of our orders are on the ERF system, and these cases are, they are fairly similar in terms of this, when you look at these projects and what information is required and what arguments have been made, how standards have been applied. There's always some differences, but I think there's some general principles that you can extract from the past decisions. In terms of substantial evidence, again, that's something that, the courts, it's in the statute, the terminology is in the statute, but it's something the courts have sort of built a body of law about what is, how much information is needed for a reasonable person to reach the decision that we're reaching. That's sort of the touchstone, and it's not clear. It's not, it depends on the case, and you could dig up past cases and compare and contrast, and that's what lawyers do, right? So there really is no definition. I totally understand what you're asking for. Like, I want a definition of these terms. These are important. But that's where the art of this all becomes. And in terms of the commission's decision, it's really the commission will weigh the evidence. It'll judge the credibility of the witnesses and the documentation that they're providing, and it'll pick what it thinks is the most persuasive, and it needs to make those judgment calls. So it has a wide discretion in that sense, but there are those sort of guide rails for it to follow. So it will need to look at what substantial evidence is, what's reasonable, what's in the public interest. Those are things it does all the time and has a sense of, and it needs to be consistent with its past decisions. So that's what you would want to do. I think your biggest your most powerful tool would be looking back to prior orders and seeing how these things have been handled in the past.
Thank you, Your Honor.
All right. So anything else?
Were we
So-
gonna finish and finalize the schedule?
Oh, did we not already? Okay, no,
No.
I was talking about the definitions, right? So at the risk of losing you all, I think we could just take a the seventh inning stretch here for just a 5-minute break. Leave all your connections on. Don't turn anything off or mute anything, or just walk away from your screen for 5 minutes and come back 3:40, and we'll talk about the schedule. But yeah, so don't change anything. We want to just get you back in 5 minutes. All right. All right, we'll start off the record here. It's about time to get back. We'll talk about our schedule now. It's in a few people, but let's get busy. So we did have the proposal, what staff has set up, the new proposal. And it looks like applicants can live with it, I hope. Sorry about that trial date there, but let's see if we can get some comments from the interveners now that we have more of a, and now that I've explained a little bit more about the filings that we're making here, whether you understand it or not now, I'm not so sure, but so why don't we get on the record? Do we have some comments from the interveners about the schedule?
Your Honor, I'd like to say I appreciate the accommodations
I'm
that
sorry,
have been made.
excuse me, I don't see somebody talking.
Okay.
Can you wave?
Yvette Lucelle.
Oh, there you go. Okay.
Hi.
You just disappeared for a minute. I'm sorry. Go ahead.
I'm so sorry. May I proceed?
Yes.
Go ahead.
Your Honor, I wanted to say I appreciate the accommodations made by the applicant for the moving it up. I think that's great, and I'm very grateful for that. I also appreciate the court and the PSC creating some more room for us so that we could exercise our rights to have our opportunity to present evidence and also rebut. My one request remaining would be that we look at the space between the initial and final brief. And if we could move a little bit closer to 2 weeks, 12 days, that would be very helpful.
Okay, thanks for the comment. Yeah, I just had some, it's off the record for a second. I just had some screen issue here, but I think, no what. Okay. All right. So let me just recap off the record. What date would you propose for the briefs? What's that? Yvette, what am I saying?
I'm grabbing a calendar, Your Honor. I was hoping for 2 weeks, 12 days. So the initial there, it looks like you were at 7/24. Would August 7th be a possibility?
For the initial brief?
For the reply?
For the reply. Okay, so initial would stay the same.
Yeah, I was just concerned about the short turnaround on the initial and the reply. Given our citizen status, I think we might need a little bit more time to make sure that that was where it needed to be to have it at your Honor's standards of making sure it's correct.
Okay.
Yeah, August 7th works better for me also.
Did Queen Wisconsin have a comment on the schedule?
Yeah, Your Honor, I was just gonna say that we're fine with the new proposal and we can live with the briefing schedule, but we can also live with it being extended.
Okay. Any comments from the applicant?
Only that I thought I heard commission staff say the absolute deadline for replies were August 1st, but
we'll get to that.
Okay.
Any other intervener comments? Okay, let's hear from commission.
Yes, I would like
Go
to.
ahead. Sorry.
I
Who's speaking
just
here?
would like to thank you for making the accommodations to make these changes.
And you support the August 7th deadline, Diane?
I'm just referring in general.
Okay.
But would appreciate the August 7th deadline. That would be very helpful.
All right, thanks.
Yes, sir. I think the August 7th for us gives us a little bit more time for us, most importantly, to be able to reply appropriately.
I just want to interrupt a sec, off the record. Someone's got like a chime going. If you could turn that
Oh,
down.
that's me. I will mute.
Okay. All
I can't
right.
seem to shut it off.
No worries.
You were off the record when you were discussing that
Discussing
about
which.
some August 7th. I wasn't paying attention because you said off the record.
Okay. When was that? All right.
When you said you had a problem with your screen and then people started talking about the dates.
Oh, all right. That's fine.
My apologies.
No, that's good. I wanted to ask you though, Debbie, can you follow who's speaking, or do you want them to tell them announce themselves first? Because there's so many people.
Well, people are popping up on my first screen here. I have about 25 people on my first screen.
Okay, so
And when they come from the other screen, they pop on here, but I couldn't see. I think there was like a glare on somebody's Miss Yvette's face that I couldn't see her. So,
okay.
yeah.
So I would say, yeah, just because there's so many people, if you could just announce yourself before you're speaking, that would be helpful for her especially. And yeah, it's a little challenge. Okay, so so let's get on the record. So we did have a one change proposed by interveners to the staff. Well, actually, we don't have any of those dates on the record, so we'll have to get those all in first. But so let's do that first. So let me say, what we have is a new proposal from commission staff. They had presented that to us off the record. Let me just get that proposal in the record first. So we have applicant direct is February 19th. Intervenor commission staff direct was April 22nd. Rebuttal May 20th. Surrebuttal June 12th. Errata June 18th. Party hearing session July 2nd. Draft transcript July 7th. The exhibits offered and received at hearing July 8th. Revised testimony July 8th. Witness verification affidavits July 8th. Proposed corrections to the draft transcript July 10th. Objection to the proposed corrections to draft transcript July 14th. The initial brief July 24th, and staff had originally proposed a reply brief to be due July 31st, and interveners are requesting that deadline to be August 7th. So we had agreement or acquiescence from the applicant to the staff proposal, and the applicant also commented to remind us that staff did have some timing issues on that last date. So if we can hear from commission staff now about the deadline for reply briefs, that would be time to do that.
I mean, I think commission staff had communicated to me that we had already moved it out some past the wiggle room that we had. That they wanted the first as the latest. And I haven't heard. Trying to see if I can get confirmation if that August 7th would be okay, but not hearing back from staff.
So I'm the dates here.
Okay. So. Alright. So I just did hear back from staff, and they said that the August 7th date, they could work with that.
Okay, if they're okay with it.
It's not too far past the first.
All right, that's fine then. So let's do that. Yeah, if they're willing to do that, then we'll just set it for August 7th. And there you go. So so that's the schedule, and I wanted to just make it known to everyone that I think within this number of parties, we'll hold the party session in Madison in person. And usually we set that at 10 a.m. And we'll also have a Zoom connection for people who, you know, for some reason or whatever aren't able to make it, but I would expect most people to be appearing in person. I think that's just going to be better for organizing the case, and having everyone there together is going to facilitate our discussions. The public session will be in Whitewater, and it's at some time around the date of the party session. I don't know, maybe a week before, maybe a week after. I'm not exactly sure. It depends on availability and getting the right room at the right time. And I just wanted to lay out some ground rules. So the public and the parties really are supposed to stay out of the public comment process. The parties do their opportunity to participate as a party is in the party process. Public comment process is where we're collecting statements from the public, getting their opinion on the case. Usually one or maybe two times they get to do that, where they're filing a statement or they're coming to the hearing and making their statement. I allow parties they can advertise the hearing, but in terms of collecting written comments, they should be the best practice is to have they can inform the public of our website and of the commission's public comment process. But I would advise against collecting comments and you really should not be collecting those comments and trying to offer them yourselves. Something that's happened in other cases, and I just in case, I'm not saying it's going to happen here, but I want to give you guys the opportunity to know this. And that is, people should be making comments on their own behalf. To the extent there are ways where if a non-party was to collect comments and produce them for us, there are certain standards I'm going to look at to make sure they're valid, but parties really should stay out of collecting comments from people. The other thing is, so we do have one Spanish speaker, at least that I know of, participating as a party. It's my intention to have a live transcription, a live translator at the party hearing session. We have to work out the details and how to do that, but we've done it before, but it doesn't happen very often. In terms of the written testimony, so I've spoken with, it's Alejandro. I've spoken with him in a prior meeting between him and Kara Kuntz and myself. We actually did that over Zoom and recorded that. So I do have a recording available if anyone wanted to have a copy of that as a party. That's fine if you want to review it. But what we discussed was his participation because he will be primarily speaking in Spanish. And I showed him how to use Google Translate to convert any written testimony he wants to offer from Spanish to English. And I instructed him to file both versions on Earth so that we have the original and then the Google version. We practice, the commission practices in English. We don't really have any rules or standards about this, so we're just kind of doing this as a novel first impression case. But I am expecting that we'll be using the English versions as the official versions for the record. And if there's any disputes or questions, we can refer to the Spanish version. We can, if we need to hire an official translator, we can, but I'm not expecting that to be too controversial. And in terms of, so at this point, I was expecting him to be using we have a closed captioning system on Zoom, does a pretty good job of translating in real time, but I think it's not going to be, it's not going to be able to keep up an entire party excuse me, an entire party session. terms of the public session, I was wondering if members of the public or if you now parties, but people in the project area, do you have any idea in terms of whether the population in Whitewater or possibly, your neighbors, people close to the project, if there's a population that does speak Spanish primarily or is most speaks another language? I'd like to know that because we can have a translator come to the public session and do live translation. And so that would be useful for our planning.
Your Honor, our community is a very large population of non-English speakers or English as a second language. I think I could say that. We've even been in the media for it.
Yes, I am familiar with that a little bit. That's why I'm wondering, yeah, if you have any insights on that, that's good to know, and I think we can use that to form the basis of getting transcription interpreters into the public session. I think that would be a useful accommodation. So that's good to know. Anyone else want to comment on that?
Yes, Your Honor.
Yeah, go ahead.
Stokowski.
Yes, go ahead.
I'll help you with that. Yes, there are plenty of translators available. I know from my church that we have quite a number of Spanish speaking. I'm sure they would be able to help. Large population there, and we are a university town, so there must be something through the university that could help us with that as well.
Yeah, we do have a contract. The state has a contract for interpreting services, but I'm just curious. It sounds like there are a number of people who might benefit from it, and that's what I'm looking to understand. So that's great. Okay, I think that's all I have. I think maybe I've worn myself out. I've probably worn you out too. Anything else people want to discuss?
Your Honor, Yvette LaSalle here. I just have one quick question.
Okay.
If in our work in data collection, we are looking for information, maybe perhaps from other areas that have been infected or maybe had solar plants put in, just try and get some read on the impact, is that qualify as okay per Your Honor's direction?
So
if we're trying to establish public interest?
Well, that would be something we'd have to look at in terms of what you file. So I'm not going to prejudge that now, but I think if you can make a case that it meets it addresses the standards the commission is applying, needs to apply in this application, then I think that's fair evidence. If it does prove that that's true. So it's something that you can offer, and we'll see to what extent there's any legitimate objection to that. I'll hear it. I think we've seen that kind of testimony in the past. I guess it really just depends on what the substance is as to whether it's relevant and applicable. And if if it does get objected to, I'll have to adjudicate that. So I'd say, give it your best shot, I guess is the.
Well, Your Honor, I have a question before I throw those resources at that. Is it something I could frame up and ask if there's any objections before I go through all that work? Because it is a substantial amount of work, sir.
No, I don't think I've seen that before. I mean, it could be something maybe you'd like to discuss with the applicant. Yeah,
well, Your Honor, that is what
really,
I'm trying to do. I am trying to come up with arguments that haven't happened before, because it seems like no one can hit the mark, not even the lawyers. So maybe we do need to think outside the bun here a little bit, and that's what I'm trying to do.
Yeah.
So I'm looking at a statistical analysis of data, prepared by people that are qualified to do so.
Right. Well, I guess I would say I don't want to really prejudge anything without seeing it. But I think what's important is that you, so when it comes to, a third party analysis, I think you're going to want to have enough of a background or enough presented in terms of the study that we can rely on it and feel comfortable that it's accurate and comes with the, that it's based in expertise. We get into some issues, and I think you can see that in past cases for the presentation of, a third party's information. That gets a little tricky as to how much you can rely on it, what conclusions you can make based on it, or if you're basing conclusions on a person who's not here in this process. We have to vet that and make sure we're comfortable with it. So
Understood, Your Honor.
yeah, those are kind of the pitfalls, I guess, is what I'm trying to say, without knowing anything, any of the specifics. But yeah, I think, comparisons to similar situations, generally speaking, that's something that we can evaluate and something at least we can have a conversation about.
Thank you,
Can
Your
be
Honor.
subject to countervailing evidence, especially. So that's good. All right. Anyone else?
Yes, sir. Alan Wood.
Yeah, thanks.
I just going back to what we talked about very briefly at the beginning, because there is so many of us. Let's say that a few people want to pair up. I know we got like 21 people, but say maybe 10 people want to pair up and 11 people want to do it on their own. That's something that's also perfectly fine.
Yes, yeah, to the extent you can group up, that's great. I think it would be helpful, especially if you can do that designate a person for filing. That would help me very much. And again, I think if you pooled your resources, you may consider, having a legal counsel get involved, but it's up to you guys. So yeah.
And then just in case on that, and I haven't dived deep into this, but I'm not saying there will be more than 30 pages. I mean, 30 pages is a lot of pages, but let's say that does happen. I mean, right now you're looking at about, if all 21 of us filed it, you're looking about 630 pages. So I guess we would have to maybe come up with something, because my guess is if you're taking 10 people and you're throwing them all in, I'm not saying that all 10 are going to have 30 pages each, but they might have 20, which obviously, even if they had 10, that still put them at 300. But I'm just wondering if there might be some room there.
Yeah, I think we probably want to address that when we get to it, because
Okay.
but I don't know if we can really tie the number of people to the number of pages so much. I mean, just to give you a kind of a heads up, I mean, it would.
Oh, sure.
Yeah, I mean, I think the 30 pages is kind of a ballpark. But I think if a party is aligned, if they have the same interests, you don't really need to say more to get your point across. So yeah, I would probably be going, it could be bigger than 30, but it wouldn't be much bigger. So it wouldn't be based on it wouldn't be like a formula based on the number of people. But I think you have to consider you may be more effective filing one really good brief rather than, 30 kind of, just everyone kind of saying what they want to say. So we'll see.
Okay. Thank you.
Yeah. Anybody else? All right. I appreciate everyone joining, and I hope we've learned something and we can take this with us further down the road, and we'll be seeing you again through your filings and through at the party session. We'll be seeing you in Madison, hopefully. Want to remind you that what did I set the date for? I believe it was
February?
February 6th for the indication of whether you're going to group up or not. So I appreciate that. Getting that filed at that time. Otherwise, I think we're good.
Excuse me, Your Honor. Will
Yeah,
you be
go ahead.
sending out that modified schedule, sir?
Let's just run with it the way it is. I'm not going to send out that pre-hearing conference memo for a while. Just the press of other work and my schedule will not allow it. But I think we can, if you take the notice of pre-hearing conference and just insert the schedule that we discussed, it's all on the transcript for this pre-hearing conference. So that you can rely on that at this point.
Okay, so it will be published there so we can get it, because I didn't write it down as you went, sir.
Yeah, so, well, let me share it for you now, so you have it right away.
That'd be great. Thank you, sir.
Yeah, sure, no problem.
Hey, Mike, I could also send it out too.
Oh, there you
If you
go.
just give it to me.
Sure.
I can send it out to the group. I know we made
Okay.
some changes on it.
That might be good. Yeah, yeah,
Thank you.
let's do that. Okay, and I'll put it up here while we adjourn.
And this is
So
Pam Stukowski. Yvette, I wrote it all down. I can share it with you as well.
perfect. Okay, you're the person that we need. Yeah, so the transcript should be served to you guys by email. So once Debbie's done with it, she'll email it to you all. And then eventually it'll be on the ERF system as well. So the memo, once I finish that, it'll be served to you by email. And really that's why it's important. The service list is important because that's the list you're going to want to use when you're emailing people your documents. And it's what the commission uses when it emails its documents, including the final decision will be emailed. So that's how we we'll communicate mostly through that process. Also, if there's anything wrong with those emails, let me know right away, so we can change them and keep them up to date. Best thing to do would be to file a request to change the service list. This way, everyone gets it right away, whether I get to it right away or not. Regardless of that, my timing, everyone will know as soon as you tell them. So, yeah, that's all I can say about that. So, all right. Anything else we need to do? Okay, well, not hearing anything. So, like I said, I look forward to seeing you, reading your testimony, and seeing you back in July. So, take care, everyone, and we're adjourned. Bye-bye.
Thank you, Your Honor.
Gracias.
Thank you.
Thank you.